We're back to give you the legal edge. Last week, President Donald Trump ignored a federal judge's verbal order on an immigration policy. A Justice Department attorney arguing in court the demand was not in writing, so the government was not bound by it. Well, we asked local attorney Brian Waldman from the Sinus law firm for his take on verbal and written orders.
In all of the cases that I've handled or seen other lawyers handle over the last 30 plus years, I've never seen a lawyer argue that a judge's verbal or oral ruling doesn't need to be followed. I've never seen a lawyer argue that because the written order isn't as detailed as the verbal ruling, that the written order takes precedent. You don't have to follow something that's in the verbal ruling. I mean, that's simply not the way things are done, and I would expect any judge to be somewhat outraged by that argument. The reality is judges are busy, courtrooms are busy, particularly in like a Michigan circuit court or district court. A judge may be ruling on issues every half hour, 15 minutes, even every 10 minutes, and to expect the judge to issue a written order on every single thing that they rule upon throughout the day is just not realistic. What happens is that the clerks will try to summarize what's done in usually a much more brief form. Oftentimes the lawyers are asked to submit orders, and oftentimes those orders don't even get submitted and entered for over a week or more after the judge enters their verbal ruling. And then beyond that, in a case like this, where a party is asking the judge to rule that another party be stopped from doing something, what's called an injunction or a restraining order, lawyers know to tell their clients, hey, there's going to be a ruling on whether you're able to do this. So the last thing you're going to tell your client to do is go out and do it before the judge rules whether or not you have the right to actually do it. And when the judge does rule from the bench, all lawyers know you follow that order. If you disagree with it, you appeal, but you tell your clients that they have to comply with it until the appeal has run its course.